Tomorrow, people are going to be talking about Colorado at the Supreme Court. The oral arguments regarding whether President Trump will or will not be allowed on the Colorado ballot will be in front of the High Court.
A lot of buzz nationally already, but before we get to that, 9 News legal analyst Whitney Traylor joins us because how did we get here? I mean, some people across the country are like, what?
Yeah,
what happened?
exactly.
How's Colorado involved?
It started right here in Denver, just up the street in Denver District Court. And so that's how it started. And the issue was there an insurrection? Did he participate? And does Section 3, the disqualification clause, Section 3 of the 14th Amendment, apply to the president? So they had this trial, and the judge determined that, yes, it was an insurrection. He participated, but it didn't apply to him as an officer. So that was then appealed to our state Supreme Court, where the state Supreme Court gave a split decision 4-3, and they said, yes, it does apply. And so that's where, from there, it went to the U.S. Supreme Court. And now we're at the U.S. Supreme Court, and they're going to tell us, because the Constitution doesn't...
Whether he can be on the ballot.
Right, and whether or not whether it was an insurrection, whether he participated, and whether the presidency, whether that office is actually included in the insurrection clause, because these aren't defined in the Constitution.
Does it matter to these 9 justices that the Colorado State Supreme Court said yes? Does that already push it in one direction or the other? Or does it arrive at their desk in the fulcrum, right in the middle?
Right, essentially in the middle, because a lot of times the reason the Supreme Court will accept a case is because there's a split in the states. So one state court said this, another said this, and there could be a number of different states ruling different ways. The court then accepts the case, they accept writ of certiorari, and then they rule. And then that ruling is binding on all courts. So in this case, I wasn't surprised that they accepted it.
I think about how in the Olympics, in like figure skating, used to have the compulsories and then the free skate, and one weighed more than the others.
Yeah.
The written briefs have already theoretically been read by the justices.
Yes.
Oral arguments are tomorrow. Does one weigh more than the other? Is one more important?
That's a good question, and I think probably the written briefs are going to be more important, because the briefs is and there's a page limit. I don't know what it is now with the U.S. Supreme Court. Right, yeah, it's not brief. It's probably 50 pages or something. And then there's a number of amicus briefs that were filed. These are friends of the court, so people who are interested filed briefs. So the court will have read the litigants, the parties' briefs for sure, and they'll have an idea where they're leaning. When they get to oral argument, that's to clarify an issue or two, or they can be swayed. But generally, by the time they get to oral argument, they have an idea how they want to rule. But of course, their positions can be changed, which goes to the lawyering, which goes to both the written brief and the oral advocacy.
Well, we have our Marshall Zellinger there.
Yeah.
It's going to be super interesting to hear these oral arguments. And then sometimes you read a lot into the questions that are asked, right, by the justices?
That's exactly right. The questions can give you an indication of where they're going. And a lot of times they can't. Sometimes judges are even harder on the side they're going to rule for, because they want to make sure it's airtight or what have you. But yeah, Marshall's there. The room is going to be intense. I mean,
Can you imagine being that lawyer?
Oh yeah,
one of them.
It's overwhelming. I mean, it's difficult being in that environment in front of the 9 justices.
In many cases, the court may listen to these arguments and not rule for months.
Yeah.
This is a different clock, of course, and they know that. What would you say is a proper timetable to expect a ruling after these arguments tomorrow? Is it a week? Is it 3 weeks? Is it months?
I would imagine it would be weeks, just because of where we are in the election cycle, and particularly as March approaches, there's a bunch of deadlines there. So I would anticipate it being, they wouldn't take the normal time that they take in their cases. And in fact, it was expedited to get here. They put an expedited briefing schedule. So I would expect it in a matter of weeks.
It'll be a big day tomorrow. We will all be following
Super Bowl.
it. Well,
those lawyers
might be more important than the Super Bowl.
Yeah,
just a little bit, but I mean, I can't imagine the pressure.
No,
the
and
pressure.
it's really this applies to this case specifically, but we don't have any case law dealing with the presidency as it relates to Section 3 of the 14th Amendment. So this is how our laws are shaped. So this is actually a very good thing, regardless of how the justices rule. We now have precedents and case law to go forward with.
Well, we're learning every day, and we're going to certainly learn more tomorrow. Whitney, it's great to talk with you about it. Be prepared for what is going to take place tomorrow.
I'll be watching.
Yep, so will we. Thanks.
All right.